Thanks very much. Chair Cass-Gottlieb, and I can see in the audience Commissioners Carver and Lowe there, I think I saw earlier as well. Welcome. CEDA trustees, distinguished guests, friends and colleagues, and a particular shout out to those who are joining us by live stream this afternoon. Wherever you are, you're welcome. Let me begin by reiterating Melinda's acknowledgement that we meet and we share lunch here today on the country of the Gadigal people of the Eora Nation, and I pay my respects to their elders and to all First Nations peoples who are here in the room or joining us online. My thanks, Melinda, and the great CEDA team for again hosting this excellent marquee event in the competition law calendar. As an economic statute, I've always felt that the enforcement of our competition and consumer law is at its heart a form of economic regulation. My clients, I think, would say it's sometimes the form of economic regulation at its most visceral. So CEDA has always appeared to me to be a fitting home for this annual articulation by the ACCC Chair of the enforcement priorities of the agency. Gilbert and Tobin are certainly proud of our long and close association with CEDA and as a sponsor of this important event now for its entire 12 years. This year, 2024, is also a special one for competition law tragics, of whom there are a large number in the room I recognise this afternoon. On the 24th of August, it will be 50 years since the date of enactment of the Trade Practices Act 1974. That marked a watershed moment in which Australia adopted a modern and comprehensive legislative framework for the regulation of competition in the interests of consumers. Importantly, given today's focus, the TPA also established a new agency, the Trade Practices Commission, forerunner to the ACCC. And so, in effect, the ACCC also turns 50 this year. Now, Gina, to celebrate that, I rather unwisely last night inquired of my 14-year-old daughter whether she would give a Gen Alpha view on what it might mean to turn 50 or to be near to 50. And based on her sample size of 1, her responses in no particular order were: it makes you boring, out of touch, embarrassing, and with consistently poor musical and wardrobe choices. I've probably shared a little bit too much about my personal journey with my 14-year-old daughter, and reasonable minds may differ about how accurate she is, mind you, on the assessment. But no one can fairly say that those words describe the state of Australian competition law in 2024. From my perspective, Gina, the ACCC has perhaps never held such a central and influential role in our national economic conversation. And this includes contributions across an ever-expanding, it seems, range of arenas, including responding to the cost of living crisis, sustainability, and addressing issues of disadvantage and social equity, including and especially amongst our Indigenous people. This, of course, is consistent with the global antitrust zeitgeist, when a few years ago the federal government would refer policy problems to a Royal Commission. They now, it appears, routinely send them to Gina. By our count, in 2010, the Commission regulated, monitored or reviewed competition and pricing across 10 markets or industries. That's not a small number. Last year, that number had grown. It had more than doubled to 24 industries or markets. As advisors in the area of enforcement, we're seeing the ACCC applying a more expansive and flexible set of tools, often more strategically. Over the last reporting year, the ACCC used its Section 155 powers in over half, or 52%, of the merger reviews that it undertook. To give you some point of comparison, back in 2012-13, the ACCC used those powers in only 14% of public reviews. We've seen the ACCC this year frequently use non-prosecutorial tools, such as infringement notices and 87B undertakings, to settle investigations including greenwashing and environmental claims, and in the first public concerted practices investigation. The ACCC's had a notably quiet year in terms of competition litigation, bringing only one new Part 4 prosecution before the courts in 2023. However, that contrasted with a busy year of consumer law enforcement and one that offered success with penalties, with the ACCC obtaining the largest civil penalty to date for cartel conduct in the BlueScope decision, as well as the second highest criminal cartel penalties just last month in bingo waste, together with strong non-custodial orders against individuals. Of course, it wouldn't be right but to finish with mergers. To date, the data suggests that the current Commission has toughened its stance on contentious deals. Over the 12 months to December last year, the ACCC blocked or refused to authorise 6 transactions, which is the highest number in any 12-month period since 2006, when it blocked as many. Many of those decisions themselves also involved more expansive theories of harm, including vertical and coordinated effects. And as we all know, Gina is continuing the ACCC's strong and strident public advocacy for the most significant and sweeping package of reforms to mergers in the 50 years of our legislation. So, the ACCC may be 50, and Gina may well have settled into her role now for almost 2 years, but there's no sign of either of them slowing down, and neither could be described by my 14-year-old daughter as being boring or out of touch. To tell us more of her agenda and the priorities of the ACCC for the next 12 months, please join me in welcoming to the stage ACCC Chair Gina Cass-Gottlieb.
Good afternoon to everyone. I too want to commence by saying what a privilege it is for all of us to be here on the beautiful land and surrounded by the beautiful waterways of the Gadigal lands. I acknowledge the continuing connection, community and leadership from the Gadigal people of the Eora Nation and pay my respects to them, their elders, past, present and emerging, and similarly acknowledge and pay respects to all Aboriginal and Torres Strait Islander people here with us today. Thank you very much to the CEDA trustees for welcoming the ACCC yet again in order to be able to herald our yearly compliance and enforcement priorities. CEDA is undoubtedly a leading critical forum for enriching economic and policy discussion in our country, and we are grateful to be included in your set of debates in relation to this. I agree with Simon that the Competition and Consumer Act is at its core economic regulation for social and political objectives, even from its inception. So if I take you back to the second reading speech 50 years ago, when the Trade Practices Act was first enacted in 1974, at that time the then Attorney General, Lionel Murphy, described the Act as providing on a national basis long overdue protection for consumers against a wide range of unfair practices. These practices cause prices to be maintained at artificially higher levels, perhaps a longer way of saying what now seems to be called price gouging. They enable particular enterprises to attain positions of economic dominance which are then susceptible to abuse. They interfere with the interplay of competitive forces which are the foundation, critically, the foundation of any market economy. They allow discriminatory action against small businesses, exploitation of consumers and feather bedding of industries. These words, for all of us, are evocative of many current political, economic and legal discussions, but I draw attention to them today, both because the year, as Simon said, marks the 50th anniversary of the Act, but more importantly for me and for my close colleagues from the ACCC, because this is a clarion call to the ACCC to champion our law. We recognise the importance of strong enforcement outcomes in achieving specific and general deterrence of conduct prohibited by the Act and ensuring that consumers, businesses and the wider community continue to have confidence in our market economy. Our priorities continue to be shaped by the key challenges facing our economy and the concerns that occupy our community. A principle amongst these are the shaping influence of the existential importance of the net zero transition, the opportunities and disruptions of digital transformation, and the significant impact of cost of living pressures across our community. Informed by this, we've continued many of the key areas of priority work from last year with new focus. I'll now outline those priorities, including a number of our enduring priorities. Due to the cross-economy impact of Australia's commitment to transition to net zero, we are continuing with commitment our sustainability priority. This priority is reflected in work across the ACCC, including consumer protection, competition enforcement and exemptions, product safety and market inquiries such as those in electricity and gas markets and in relation to the Northern Australian Cyclone Reinsurance Pool. Each of us here know that many Australian consumers want to reduce the negative impacts of their consumption choices on the environment and choose to purchase goods and services that are marketed using claims about reduction in environmental impact. It is important that claims are accurate, substantiated and aligned with the understanding of the ordinary and reasonable consumer. It's a very important term for the ACCC, ordinary and reasonable consumer. In December 2023, the ACCC published principles-based guidance to assist businesses in making clear and accurate environmental claims, and I want to thank many of the people in this room who engaged with us over a number of months in relation to our draft guidance before we finalised it with the benefit of that consultation. We have a number of in-depth greenwashing investigations underway, including in the energy and consumer product sectors. As Simon noted, we did resolve our first public enforcement action in relation to ocean plastics last year using an 87B undertaking. During this year, we will issue guidance in relation to treatment of public benefit in facilitating the transition and improvements in sustainability in our assessment of conduct authorisations. It's interesting to note that over the last few years, 1 in 4 conduct authorisations considered by the ACCC have involved assessment of sustainability-based public benefits. So that is in addition to the consideration last year in the Brookfield Origin merger authorisation application. We are also prioritising product safety and sustainability, particularly around electrical products. Following a recommendation from the ACCC, many will be aware that the Assistant Treasurer recently issued a proposed recall notice for specified LG solar storage batteries that can overheat and catch fire without warning. In the current circumstances of rising cost of living, Australian consumers are even more vulnerable to the effects of anti-competitive conduct that reduce competition in the supply of essential goods and services, restricting entry or expansion of competitors, reducing choice and contributing to price escalation pressures. We are also very conscious that misleading sales representations in relation to the price, features or benefits of essential goods and services prevent consumers making informed purchasing decisions, and this is of even greater harm in times of reduced household disposable incomes. Our priorities in relation to a number of sectors are informed by this critical context. This year, the ACCC will prioritise competition, fair trading, consumer protection and pricing issues in the supermarket sector with a focus on food and groceries. This new priority reflects significant price increases in food and groceries, 14.1% over 2 years, and the concerns of many Australian consumers and farmers about supermarket pricing that have been expressed publicly, expressed directly to the ACCC, and clearly informed the government direction to us in January to conduct a 12-month price inquiry into competition in the supermarket and grocery sector. This inquiry directs the ACCC to conduct a detailed examination of competition, changes in competition, and of supermarket pricing practices, and the relationship between wholesale prices, including farm gate prices received by farmers, and retail prices paid by consumers to supermarkets. The inquiry has commenced. You may very well have seen that last Thursday, 29 February, we issued an issues paper and at the same time an online consumer survey, both of which will be open for submissions and responses until the 2nd of April. In addition, we have been closely considering reports from consumers to us alleging false or misleading was now or other pricing specials advertised by supermarkets and whether they may raise concerns under the Australian consumer law. In addition, we will be building on our body of work to date in telecommunications, electricity, gas and financial services sectors, and we'll be prioritising competition and consumer protection issues in these sectors. Vigorous competition in these essential services is critical to the efficient functioning of the economy as a whole. Enforcing new gas market regulation remains a priority for us in 2024, while we continue to review information in respect of prices under contracts entered within the price cap period. The focus of our monitoring is definitely shifting to gas market code compliance, which took effect in September 2023 and applies to gas producers with the overlay of exemptions granted by the respective ministers. In December 2023, the ACCC established a new anonymous complaints portal to assist with detecting non-compliance with the code, including, potentially, avoidance behaviour. As consumers cope with cost of living concerns, it's important that businesses are accurate about the price and product performance of essential services to allow consumers to be able to make informed decisions about their choices. For example, mobile phone coverage, data speeds, off-peak tariffs, environmental benefits are just some examples where consumers grapple with a complex decision-making process when trying to differentiate between otherwise apparently similar services. Over the past few years, you will be aware the ACCC has both monitored, released monitoring reports and continued to take cases in the energy and telecommunications sectors because of businesses engaging in false and misleading representations. These actions and surveillance of these sectors continue to be a key priority. This year, in addition, the ACCC will be prioritising competition and consumer issues in the aviation sector. We have identified in our first airline monitoring report under our reinstated direction that rates of cancellation and delay remain above long-term averages and that Australia stands at a truly critical point in relation to the opportunity for increased competition. We have the entry of a fourth airline competitor for the first time on one route, and more than 2 competing airlines on 1 in 2 domestic routes. In addition, the ACCC continues to receive, unfortunately, a high number of consumer complaints in relation to airline services. We believe that increased competition will be an important driver to addressing many of the concerns raised by consumers about the airline's services and pricing practices. The reinstating of our role in monitoring the airline industry will allow us to look more closely and follow through on allegations of anti-competitive behaviour and unfair business practices. Consumer and fair trading issues in the ever-present digital economy will continue to be a priority for the ACCC. This year we will focus on misleading or deceptive advertising in influencer marketing, online reviews, in-app purchases, particularly in video games, and price comparison websites. Influencer marketing, online review and comparison tools have become a critical key to reaching consumers for advertisers and persuading them to choose particular products and brands. They've also become a tool for some businesses to manipulate and unfairly influence consumers' decisions. Finally, we will be looking closely at the video gaming industry, particularly in-app purchases. This industry has significant size and reach, particularly with younger consumers. Far too often we hear concerns about consumers incurring huge purchases because of in-app offerings that have inadequate safeguards or, in some cases, deliberately target and nudge or confuse consumers. Unfair contract terms, of course, continue to be of considerable interest and priority to us in consumer and small business contracts. They are now supported by penalties for contravention. Clauses that seek to unilaterally vary agreements or impose penalties for termination are, in our view, unreasonable and make it difficult for consumers to cancel or end agreements. The ACCC has undertaken a review of a range of standard form agreements, and we have matters currently under investigation. You may be interested to know that consumer guarantees are the most complained about issue raised with the ACCC and with each state and territory consumer agency. The ACCC has a number of active investigations and cases underway. You will have noted our commencement at the beginning of this week of the Mosaic Brands case concerning consumer guarantees. This year we are expanding our enforcement focus to the consumer electronics sector. The ACCC and other consumer agencies have recently noticed an increase in complaints from consumers in relation to the delivery time of consumer products, often purchased online. There is a concern that misleading conduct by retailers about delivery time frames not only impacts consumers' decisions, but also has an impact on those businesses that are accurately representing the true delivery time frames. In view of poor compliance with the consumer guarantee regime, there is a need to consider what more should be done. We consider that the law should be strengthened, access to justice needs to be improved, and a culture of compliance by manufacturers in their dealings with retailers and by retailers in dealings with consumers is essential. One important reform the ACCC considers is necessary is for failure to honour consumer guarantees to be a contravention of the ACL, incurring penalties, allowing the ACCC to take action directly in respect of a continual pattern or conduct of failing to honour consumer guarantees. A number of ACCC stakeholders have raised concerns about inadequate mechanisms under the NDIS framework for participants to receive protections under the Australian Consumer Law. To address these concerns, the ACCC has commenced chairing a joint task force involving the NDIS Quality and Safeguards Commission and the NDIA. This is an important initiative, and the ACCC is keen to assist the Safeguards Commission and NDIA in improving compliance by NDS providers with the ACL. The ACCC has also committed additional resources to identify and act on consumer law matters that may arise from the conduct of NDIS providers, concentrating on investigations of systemic and/or serious consumer law breaches. It won't be a surprise to anyone in this room that taking action on cartel conduct is at the heart of the ACCC's role as a competition enforcement agency. Simon referred to a number of key matters that have taken place and come to judgment in the past year. Cartel conduct is and will remain an enduring priority. We have indeed had successful outcomes with proceedings in civil and criminal cases across steel manufacturing, professional and technology services, and waste processing. What was important in relation to the judgments in Bingo Industries and Aussie Skips was the combination of the second highest corporate penalties, the criminal sentences of imprisonment to be served by intensive correction order to the two former CEOs, and their banning for 5 years in relation to management positions. But in addition, that Justice Wigney commented in delivering the sentences that the fines imposed for such offences must be sufficiently high that they could not be regarded to be an acceptable cost of business. They must also be sufficiently high that others who may be tempted to offend will come to appreciate that the risk of having a substantial penalty imposed well outweighs the likely benefits from the anti-competitive conduct. We have a robust cartel enforcement program with matters currently before the courts, as well as some important matters in our enforcement pipeline. Looking at the ACCC's competition enforcement program as a whole, the fines awarded against Bingo and Aussie Skips bring the total fines and penalties awarded in ACCC competition law cases decided during this financial year to in excess of $100 million. This is the highest total ever achieved by the ACCC in a financial year for competition law breaches, and should send a strong message that the actions we are taking are achieving and designed and targeted to achieve specific and general deterrence. We have added the fight against scams by the National Anti-Scam Centre as an enduring priority. The NASC was launched last year and has brought together all key parties within government, law enforcement and the private sector to advance strategies for an across-government and key private sector organisations' approach to combating scams. The first fusion cell, established in July 2023, has worked to address the scourge of investment scams in the community. Together with ASIC, banks, digital platforms and the telecommunications industry, this fusion cell has referred over 800 offending sites for takedown. It continues to actively share intelligence with law enforcement and the private sector to disrupt scams. We have now seen, and are pleased to say we have seen, the 6th straight month of declining losses in ScamWatch reports compared to the corresponding month in 2022. All of this is positive, but the job is far from done, and a whole of ecosystem legislative framework with mandatory enforceable codes remains critical to ensure Australia becomes, for all of us, we believe this is our target, that the world's hardest target for scammers. This year we are establishing a dedicated First Nations coordination, outreach and advocacy team to meet with, build stronger relationships with and listen to the voices of Indigenous communities that will help inform and align all of our activities across the whole agency regarding conduct impacting First Nations Australians. We have also added our work to protect the small business sector as an enduring priority. Small business is a significant contributor to our economy and supports the livelihood of many Australians. It's therefore critical that small business receives the protections of both competition and fair trading laws, also referred to, as you heard, in the Attorney General's second reading speech in 1974, and small business codes of conduct, including in the agriculture and franchising sector. Finally, product safety remains and always will be an enduring priority for the ACCC. Our commitment to supplier outreach and consumer education to raise awareness of risk alongside our compliance and enforcement activities aim to improve product safety for all Australians now and into the future. The safety of young children will be a key focus of our product safety work throughout 2024. As you can see, and indeed as Simon noted, the work of the ACCC is broad and diverse and continues to grow. But our public purpose as an agency remains strong and focused on enhancing the welfare of all Australians. As we progress our priorities and our work program, we will exercise our enforcement powers always independently, in the public interest and with integrity and professionalism. I'm truly looking forward to the year ahead. Thank you.
Thank you, Gina. And once again, and you know, I've been to a few of these now, it never ceases to amaze me what a tour de force it always is to hear the agenda ahead. And this one is as jam-packed as any, I think, that I've heard. What strikes you immediately is not just how much you've got on your slate, but how broad the framing of those issues are. And I think if you went back 10 or 15 years, you wouldn't find, I mean, just to rattle off a few that sustainability, cost of living, a focus around the NDIS, scams, and a focusing around disadvantage of our First Nations Australians. I mean, they are a set of social attributes and an emphasis that I think is clearly observable as something that's grown in the last 3 or 4 years. So we look forward to hearing you speak more about that, both of the breadth but also the emphasis and the priorities. There does seem to be an evident shift toward a greater focus on consumer law and consumer law issues. Not to say that the Part 4 isn't buried in there, but it's very much a consumer-orientated, I think, presentation this year, which is interesting. And I note the continuing growth in cross-governmental activities with scams and NDIS and sustainability. I think that's worth noting as well. I think very, very, very valuable. Look, we're going to move to the Q&A now. We've got Gina again this year has generously allowed half an hour for questions. I'll just reiterate, if you want to log on to Pigeonhole, the details are on the screen behind me. I understand those that are following along via live stream, there's a URL that you should have available to you, so you don't need to miss out. I'll come over here, Gina, and we can make a start, but it's a bit of a vox pop, so don't feel you have to put a question in. I doubt we'll get through all of the questions we've already got on the iPad, but I think as people vote, they'll move up and we can prioritise questions based on their popularity. All right. Yeah, am I on? Here we go. Well, while we're waiting for... Oh, that seems very loud. Is that echoey? I think my colleagues would say I'm loud enough, Gina. Before we jump in, I'll let people vote and get this thing cranking, but it's maybe a Dixer to start. It's been 2 years, or almost 2 years, 2 years in May, I think, since you left us. March. Oh, there you go, even closer. And I suppose... just sitting where you are now, I mean, after almost 2 years, it's probably not right to speak of you as the new ACCC chair anymore. What's your most pleasant, I guess, observation or surprise, having now spent a couple of years in the role? And don't say it's access to Section 155 notices.
Why not? I always had a deep respect for the ACCC. What is the most pleasant surprise is the stimulation and inspiration every day of going to work with the people that I work with at the ACCC, with my commissioner colleagues, senior management colleagues and everyone united by a common public purpose and really keen to make a real difference. And as we face increasing requests for work based upon the rigour, independence and integrity of the ACCC and the capacity to maintain the trust of the community in what we do, we are calling upon our people every day to deliver on that, and it is a great privilege and honour to work with the team at the ACCC.
Jumping into some substantial questions here, and there's a number already that are racking up votes. It won't surprise you to know, Gina. Let me start with a reference that you made, and you sort of you emphasised it, the importance of this concept of an ordinary and reasonable consumer in the way that the ACCC thinks about its prioritisation of enforcement, particularly I'm guessing in ACL matters. How do you think about that, or how does the agency think about what is a reasonable expectation of consumers, particularly in relation to the choices and the ownership that those consumers make when they're engaged in commerce?
So firstly, we ask ourselves, who are the main sections of the whole range of consumers that particular representations are made to? And if they're made to particularly disadvantaged consumers or consumers experiencing vulnerability. So for example, last year the ACCC received a $438 million penalty in the Phoenix Vocational Colleges matter, where the judge said that it was the most predatory and exploitive behaviour against the most disadvantaged consumers. So in that case, we are asking ourselves, what is the capability of ordinary and reasonable consumers of this group to understand what is being put to them? We're often given a response that says, well, if the consumer moves to 6 screens lower and read that particular condition in small font, that they would have found out exactly what this was. But we know most of us, in fact, are even capable, more benefited by education, don't have a lot of time to go through those processes. So we are asking, what is the ordinary and reasonable consumer in these circumstances likely to understand? And that area, and I mean, you touch on the dark patterns work that you've done and the sort of analysis that's been done by the Commission around those. And I think greenwashing, again, has been a priority now for a couple of years, and I can see it's a priority again this year. That priority, greenwashing and dark patterns to an extent, has been around for a couple of years. We haven't seen any cases brought to trial. We've had, I think, Oceans Plastic. Yes.
and I think a couple of infringement notices were issued. Is that an issue that they're still working their way through the pipeline, or is it actually that you've taken a different engagement model with business, or that you've in fact found when you've gone further that business perhaps was able to substantiate the claims that they were making, or a combination of those things?
There has been, in relation to greenwashing, a considerable period of emphasis on developing the guidance and building compliance in that matter. We did, in the Moo Products case, in relation to ocean plastics, resolve using an 87B. We do expect to commence proceedings in the coming period from a greenwashing perspective. In addition, a number of our actions have been in relation to misleading and deceptive conduct, or anti-competitive conduct actually, in an online trading environment. So the Brilliant Lighting one, which was an RPM, but it was an RPM about a restriction on headline prices on websites. And in addition, Mosaic Brands is looking at misleading and deceptive representations relating to online sales. So we have had a range of actions, including litigation relating to conduct in the online environment. You are right, we are also very focused upon manipulative behaviour in an online environment, in terms of the flow of screens, the flow of prompts, the use of colours. And so if you look at the matter that is going through the courts in eHarmony Inc., that matter, which in part is about subscription traps and misrepresentations, does have elements about what was shaded out, what was available. So it does have elements as well, because many of these online trading matters, in fact, involve a range of these aspects from a factual point of view and also from a legal point of view.
Staying with consumer issues, but perhaps changing gear into the grocery inquiry. The question's asked, and I think it's a good one. Certainly received some votes, Gina. Grocery prices have obviously risen strongly here in Australia, but I don't think we're unique in that regard. Do you have a sense, or does the Commission have a sense, to what extent our experience or lived experience with grocery prices here in Australia is unique, or whether it's just a reflection of global trends?
So these are aspects that we do need to look at very closely. The public discourse that has occurred has suggested that while there were undoubtedly, coming out of COVID, significantly increases in supply chains, that a range of those have been moderated or passed through, and that in other jurisdictions there has been a return to more prior to COVID levels of price competition. But all of that, though, we need to investigate. This is, we're going to have a combination of broader consideration against international benchmarks and aspects like that, and some very detailed consideration from the farm gate through processing, wholesalers and traders, to look at the flow of costs in the supply chain and also margins. So we will look at this in a very detailed way.
I'm going to jump to it because it's the top rating question, even though it's a merger question, and I know it's an enforcement lunch, but this won't surprise you. I know you've, as we all have, carefully digested the 898 pages of Whitney's judgment, and what are the lessons for the ACCC from the tribunal decision in ANZ Suncorp?
The first lesson is that we consider that this administrative decision-making process is a strong one, and that it's one that has checks and balances, that it ensures that the right matters come before the most capable decision makers. In the tribunal's case, an extremely experienced economist, extremely experienced judge, and a lay member. And you can see it in that judgment. It is extremely carefully and well set out on economic principles, legal principles, and views upon the facts. And for us, it is a key signpost to what is the most, we say, competent, efficient decision-making mechanism in such matters. The second aspect that we take, particularly for the banking sector, is that the tribunal did see aspects of the market structure and conduct within the sector in a similar way to the ACCC. Of course, I know very well, and everybody is thinking, but they reached a different decision. Don't worry, I'll get to that. However, the tribunal did find that the four major banks have stayed the same four major banks for many years, that, and this is the tribunal's language, that they hold dominant market shares, that they hold 72% of the assets, that they are prone to coordinated conduct, yes, and that there are high barriers to expansion for entrants, including, importantly, in respect to the ability to access the least costly finance, and also in terms of the absolute criticality of having scale in order to develop necessary technology to enable all of the banking technological applications that many of us use. And in fact, the tribunal found that that was a critical rationale for the transaction, for the ability for ANZ to leapfrog to a higher position in terms of that scale, and that scale was a significant deterrent and barrier to expansion for smaller competitors. In that context, we consider that the core factual findings are the same as the core factual findings that the ACCC found. The tribunal did then, in weighing the matters, reach a different conclusion. I acknowledge it found that it thought that there were factors that were reducing the propensity for coordinated conduct, but they thought that would happen over time. The ACCC is less optimistic about what will happen over time, and for us, it's our role to monitor and watch these things. The tribunal will wait. It may be given another matter, it may not. But for the ACCC, it is very important to protect and promote competition in such a core sector. And the tribunal's decision definitely points to the same areas of concern that were the ACCC's concern. The one or other aspect we think is important for all of us here in this room as practitioners is the tribunal took the same approach to what is a public benefit for the purpose of assessments in merger authorisations, and accepted the integration synergies. It put more belief in the likely achievement of them, but the ACCC had also accepted that, but found others were either not sufficiently flowing from the transaction or not in the nature of public benefits, which was the same analysis as the ACCC. So we acknowledge and we accept, as you've seen, we've stated we're not going to seek review. We accept the decision, but we do say that it sets out for us the importance of watching the sector closely. It's critical as an essential service for consumers and businesses, and we do think that it shows a similar view as to the areas for which we needed to pay particular attention and concern.
Is it, I mean, I note that, you know, you very recently published the merger reviews, the ex-post merger reviews, and I think you've stated publicly, or the Commission stated publicly, it doesn't intend to do that for those cases where the Federal Court or the Tribunal has allowed mergers in a sense. Is there a reason for that? I mean, can you elaborate on why? For example, I mean, to take your point, that you were saying just then that clearly the Tribunal perhaps takes a more optimistic view about aspects of the emergence or the development of competition over the longer run. They appear to me to be the logical sorts of areas for the Commission to come back to in 5 years and revisit and see if, in fact, that optimism was warranted.
Well, we certainly see a real importance in ex-post reviews. We also can see that one of the benefits in the public interest, to business, to practitioners and to the economy of a mandatory suspensory regime with notification of all important transactions above what would be if the government were to endorse reform, the particular thresholds will give a much better capacity to have data that will inform what are the implications of either approving or not approving in relation to particular sectors, and those aspects will better inform into the future. At the moment, with our ex-post reviews, you'll be aware we recently released one. Because we do not have compulsory information gathering powers there, we are relying on participants' voluntary and anecdotal information. It gives interesting information, but it does not allow a proper analysis of what have been the implications of either a decision to approve with conditions, and you have seen we did note in one case that the basis upon which the undertakings had been accepted actually had played out as best as we could see.
Yep.
But in the other, some aspects appeared not to have, based upon what other competitors and customers were telling us about the operations in the port in the particular area. So they do pose important questions.
Let me shift beyond mergers to a favourite of mine. Obviously, the big event this year for competition law will be the mammoth 16-week epic trial come March or thereabouts, and that will be one the ACCC will be sitting on the sidelines of, like many of us, observing with interest, no doubt. But it also does, I suppose, heighten the focus on the fact that the ACCC has been quiet in the area of Section 46. I don't think in the 5 years since Harper we've seen, or the reforms were introduced, we've seen one come to trial. Of course, we had TasPorts, and we've still got MasterCard, but MasterCard itself is a purpose, as I understand, is pled as a purpose case. I suppose the question there is, can you comment on the fact, is it too hard to bring an effects SLC type argument in the context of Section 46? Do you have any in the pipeline? Or perhaps you want to comment more generally around the ACCC's enforcement focus or not on that provision?
We do think that MasterCard will be a very important case. Because it will, while it has a particular focus on purpose, the evidence will give insight into the question of effect and the question of whether that strategy, which of course are solely allegations at this time, whether that strategy had an intent and potential effect of restricting the ability for the lower cost FPOS service to expand. And so we do see it as a very valuable case, including because payment system cases are very applicable in other network industries and throw interesting perspectives in terms of exclusive agreements and how they may impact and positions, because that is being argued under 47 as well as 46. It is in the manner of competition cases that they are more complex to investigate and more complex to bring through to commencing prosecutions. We did have 2 successful RPM proceedings last year, and the highest penalty ever in an RPM matter. And so they are competition matters. We also have had a range of cartel matters. We do continue to look at 46 and 47. We are also continuing to look at concerted practices. Yes, it has had an 87B resolution, but these are matters that will take their time to be worked through, for the Commission to be satisfied. We do have investigations in each area, but to be satisfied they are appropriate cases to take and then to build up jurisprudence. But I am not surprised about that. Historically, it has also been an area for many years that the ACCC has taken carefully. We do benefit from getting deep expertise in a range of the sectors that we monitor, which does give greater capacity to take forward these sorts of assessments. But we're absolutely committed on these competition cases, and in essence, wait and you will see.
I have no doubt. I might pause from the iPad and see, just for a moment, I'll just stop and see if there were any questions in the room, at the risk of me making a comment about you being out of touch and not able to use technology. But I won't do that, sir. Have we got a microphone? If you could just give your name and your organisation, and then that'd be terrific.
Thank you. It's John Keogh from the Australian Financial Review. I think Paul Keating said in life, always back self-interest, and as a member of the Fourth Estate, I'd like to ask you about the Meta and News Media Bargaining Code. The Assistant Treasurer, Gina, has asked you to investigate whether there's a significant power imbalance in negotiating between Meta and the local media companies. What's your preliminary sense around that, and what are the key factors you're going to be considering in that advice to the government?
Thanks, John. We have now received that request. As everyone in this room will be aware, between 2017 and 2019, the ACCC did a very significant investigation in the digital platforms inquiry and did conclude at that time about a significant imbalance of bargaining power, and it resulted ultimately in the News Media Bargaining Code. We do take seriously that we must now look at current market conditions, and we must consider that afresh and do so on the basis of the information that we gather from the news media organisations and from Meta and from other stakeholders, public interest journalists. There may be a number of possible stakeholders who will wish to bring information to us. We intend to do this as promptly as possible. There is a high degree of public interest in addition to, as you were referring to, the self-interest. We will be doing that in an evidence-based and independent manner.
Are there any other more? Got a question.
Gina, Adrian Cootie from Clayton News. Just a quick question going back to the consumer law matter that you raised in relation to consumer guarantees.
Yes.
I was quite interested to hear, from you what you see a prohibition adding that would not already be covered under, for example, the misleading and deceptive conduct cases that are routinely brought in relation to consumer guarantees.
Thanks. So currently with consumer guarantees, consumers can take action so of course they contact the supplier. We hope that they receive the remedy that they're entitled to, but if they don't, it is actually very difficult for individual consumers to obtain access to justice, as everyone here would understand. When the ACCC takes these actions on, we do generally need to rely upon, because we do not have a right ourselves to say that that's a contravention of the Act, not complying with the obligation to deliver the consumer guarantees. So generally we do take them as misleading and deceptive conduct cases. The problem with that is that it's a problem that we find with all these ex-post enforcement regimes. Every lawyer in this room knows what we then need to do is be very specific in the pleading. What were the representations? Who were the consumers affected? It is not a sort of whole of system until you get to a penalty question, but then it only applies to the facts that have been found in the court. We may very well have a business that has routinely for many years confused consumers, given partial or no remedies, but we can't actually take action that this has been a serious failure to comply with the Act to provide consumer guarantees. And so either
all other solutions, including binding ombud solutions, and we do talk about that as well, can give some answers to the difficulties of obtaining justice for consumers. But we would like, in conjunction with that individual, a better method of resolution of individual claims, to be able to take on the most serious offenders and to set principles as a norm. At the moment, our view is, and it is the view of the state and territory consumer regulators, that there are poor levels of observance of the consumer guarantee obligation.
Gina, I don't know how many more questions we've got time for, but I made an observation in my introduction that certainly from an advisor's perspective, we are seeing the Commission use a broader range of tools, and in many ways, perhaps more strategically. That's not to say it wasn't done in the past, but whether it's infringement notices, we're obviously seeing 155s used more, and sometimes quite creatively in terms of not 155 so much, but whether it's disqualification orders, which we haven't had as much, and more recently we're seeing more of, the way pleadings are structured. I suppose two questions, and one of them is on the iPad and one of them is mine. Is that just a case that you've stolen all our best people and now you've got, an ability to, and it's quite an intentional, broadening of the toolkit that you're using in your investigations? And secondly, a question has been raised. To what extent does the Commission, thinking about, for example, the fact that now we're seeing 155s issued in more than half of public merger matters, a lot of those go to non-merger parties at times. To what extent does the sort of burden of the 155, particularly for non-parties, feature in the way you think about your enforcement sort of process?
So I'll start with the answer on 155s, but then I'd like to talk about the broader use of tools in a public enforcement way. We're very conscious of the question of regulatory burden that we do every time I consider a proposed notice, and the reason to believe I am asked that question and I am given an assessment in relation to it. And we do seek, through pre-consultation whenever practically possible, to engage in advance in relation to scope and in relation to time frame, in order to take into account submissions that are put on burden. One point that I would really encourage everyone here, both as practitioners and businesses, is that actually this burden will be reduced if you come to us early on in a cooperative fashion. I know that sounds self-interested, John, in the way you spoke, but actually it's a shared interest, because if you engage with us in that manner initially, much of what ends up being more burdensome and inefficient for us is when we find that there is an incomplete provision, and going to third parties does help us sense check and test what we have received. But if it appears to be incomplete or potentially strategically so, we get more sceptical, and it produces a bigger set of requests, and it also leads to a much less efficient investigation process. So it is in everybody's interest, ours and yours, that we deal in a more upfront and open way from the beginning. The other aspect in terms of the breadth of tools, so faced by the question of multiple small but still significant breaches. So franchise is an example. With multiple victims, small business victims who can never get their own justice, and to also face inconsistent incentives about whether to give evidence or not. We are, and this happens in multiple industry codes, we are trying to do what I think Rami calls, and if I have it wrong, Rami, you can call out and tell me I've got it wrong, a sort of faster, louder, stronger approach, which is to move quickly to identify what the problem is and to seek to get a resolution that may be an infringement notice or an 87B, but not lead to a situation in which, though if we do have the evidence, we will of course take court proceedings, but not have a situation in which we may be unlikely to get remediation. You will also have seen that we are seeking, wherever we can, to have consumer redress, small business redress orders, and we are, so it was there in Airbnb, for example, there in Grays. We are proposed in Grays. There you see that our objective is to ensure that as far as possible the action does deliver real recompense and redress, and that is a principle that the Commission at a senior manager and commissioner level has decided we will undertake wherever it is practically possible.
Gina, I think we could sit here and chat for another hour or two, and we'd keep getting questions. Broad and candid and up front, I think, covers the last 45 minutes very well indeed. Thank you so much for your time. Melinda's on her way back up. All that's left for me to do is to ask us all to thank Gina for her time and her candour this afternoon.
Well, thank you, Simon. Gina, I don't envy you the task, I have to say. As I was listening to your answers and the breadth of issues that are coming just from this audience, it's very clear that we live in a complex and fast-moving world, the dimensions of which are significant in the context of consumer choice and informed choice and business operations, and the importance of competition, which is really important in terms of ensuring that economic growth actually delivers in the public interest. So we are very much aligned with you on that. I'm going to take one of the comments that you made and perhaps take it slightly tangential to the work of CEDA. This point about engagement and exploring issues and trying to get to the best outcomes, that is of course at the core of what we're trying to do at CEDA. I think one of our great strengths is that we have such a broad membership, and it does provide the opportunity for us to have frank and fearless conversations around regulatory and policy intent, its effect in practice, and how we can make sure we get the very best outcomes that support a dynamic, productive and innovative economy, but always in the public interest, because that is what is so important in terms of sustaining the economy and the opportunities that the economy that we live in and the opportunities that are so important to us. So that is an open invitation to reach out to us if there are issues that you think need to be discussed publicly or in Chatham House. If policies are working or not working, we can create those opportunities in the spirit of advancing really good policy for a strong economy and in the interests of the broadest community and community wellbeing. So a bit of a plug for us in that too. Gina, thank you again for taking the time. I greatly appreciate you being on the CEDA stage and being so generous with your time and the way in which you're explaining issues to the audience to help them to understand what you're trying to do and why. It really is at the core of what we do, and I appreciate your ongoing support for that. And Simon, likewise, thank you for you, and to Gilbert and Tobin for supporting this event. A quick plug for those of you here in the room and online as well. We've got the Treasurer next week in Sydney. There is a lot going on in the economy. We can have lots of conversations about the GDP results and per capita GDP outcomes and all the rest of it. So great opportunity to be in the room with him and to ask the questions that really matter for you. And then early in April, we have the New South Wales State Health Outlook with the Honourable Ryan Park. So some important issues on our agenda. Thank you so much for being with us. Thank you to those of you on the live stream for joining us. And I look forward to seeing you at a CEDA event soon in the future. Thank you.